Parimal, are we ready to start?
Yes, sir.
Or shall we wait for some time? Some more participants are joining.
No, sir, we can start, sir.
We can start. परिमल के नोट्स करना मेरे 1 2 3 वाले ये वाले हम हमारे वो मेरा किया दिस यू कीप यहाँ से ये लगा everybody yes in a summer vacation, keeping you busy, keeping all of you busy. Elections are there. Now we are also taking lectures. Now today we'll discuss the various provisions of the new criminal law legislations, namely the new CRPC, that is Bharatiya Nagarik, Bharatiya Nagarik Suraksha Sahitya 2023, that is the CRPC. The names are given in Indian language, very nice. Then we have Bharatiya Nyaya Sahitya, that is the Indian Penal Code. Then Bharatiya Saksha Adhinayam 2023, the Indian Penal Code. In a way, it is a remarkable progressive step on the part of the government to bring about the changes in these three composite legislation, which are more than 75 years, more than 150 years old. Now I will give the brief history of the litigation, how they were brought. So all of you know that prior to the British came into picture here, India was governed under the Mughal rules. We had Nizamat Adalat, we had Mufassil Adalats in various provinces. Then when the Britishers came over to India, in the year 1834, the first law commission was set up. 1834, law commission was constituted under the chairmanship of Lord Macleod to examine the jurisdiction, power and the rules of existing court, as well as the police establishment and the laws in force in India. The Macleod Commission suggested various enactments to the government. One of them important recommendation made by the Macleod Commission was on the Indian Penal Code, which was enacted in the year 1860, and the code, namely IPC, still continues in the country, with some amendments made here too from time to time. In the CRPC of the year 1973 is also a very old legislation of the year 1868, made by the British government, amended by the government of India from time to time. Then Indian Evidence Act 1872 is also a very unique legislation where minimum changes have been brought about. But the present government considered to make the existing laws relevant to the contemporary situation and provide speedy justice to common man. Accordingly, various stakeholders were consulted by the government of the day, keeping in mind the contemporary needs and the aspiration of the people, with a view to create a legal structure which is citizen-centric and to secure life and liberty of the citizen. That is what the statement of the Honorable Home Minister in this regard. Now, in March 2020, the Criminal Laws Reform Committee, headed by Professor Dr. Ranbir Singh, was set up to study the report and the lacunas in the criminal system and suggestion for improvement. In February 2022, Dr. Ranbir Singh submitted the report on 3 criminal law bills. They were submitted simultaneously. 11th August 2023, the bill, namely Bharatiya Sanhita, was introduced in the Lok Sabha along with the Bharatiya Nagarik, Suraksha Sahitya and Bharatiya Sakshi Adhiniyam 2023. Then on the 10th of November 2023, all of you know that the bills were referred to the Parliamentary Standing Committee, which gave recommendation and the report that there are certain lacunas in the bills and the bills were withdrawn. Then thereafter, the various committees of the government, after rectifying the defects, the bills were again reintroduced on 28 December 2023. It was reintroduced in Lok Sabha on 28 December. 21st December, it traveled to Rajya Sabha. Then on 25th December, the President of India gives her assent to the bills. Now, the 3 acts with substantial changes has not yet come into force. It is expected to come in force with effect from the 1st July 2024, all the 3 acts. Yeah, all of you know that here we will discuss all the 3 acts in these lectures. All of you know that here we will first take up the procedural law, namely the provisions of Bharatiya Nagarik Suraksha Sanhita 2023, Criminal Procedure Code, a procedural law which tells you what are the criminal codes, how the criminal law is set into motion, and how to implement the substantive law, namely the Indian Penal Code or the Bharatiya Sahitya 2023, which is a substantive law which deals with the rights and liabilities of the accused and the complainants. Then, of course, the Bharatiya Sakshi Adhinam 2023, which is Evidence Act, which is neither a procedural law nor a substantive law. It is known as an adjunctive law. The adjunctive law's role is to find out the truth of the matter, how to prove the rights and liabilities before the court of law, what kind of evidence should be introduced before the court of law, the facts and issues, the relevant fact. You know that under the Evidence Act, we learned that you must have the facts and issues before the court. Evidence cannot be led without there being facts and issues. Facts and issues, as you know, in the Code of Civil Procedure Code are framed after the pleadings are completed, taking resort to the provisions of Order 14 of the Code of Civil Procedure. Under the CRPC, when the charge sheet is filed by the police officer, charges are framed by the Court of Sessions magistrates, and the matter is set on for recording the plea of the accused person, and the trial commences and evidence is required to be laid. The government of the day felt that there are substantial delays which are being caused in the court on account of several discrepancies, on account of several provisions which do not lay down mandatory period for a starting and completion of the investigation. There is no time limit fixed for a judge to give his judgment. There is no time limit fixed for examination of the witnesses. The provisions are not victim-centric. In the provisions of the CRPC and Indian Penal Code, you will not find beneficial provisions for the victim. Earlier, there was no provision in the Indian Penal Code or CRPC. The victims were not entitled to a copy of the FIR. Now, fortunately, the legislature, the parliament has made compulsory that the investigation officer must provide copy of the FIR. And when FIR is filed, the police officer does not start investigation. A preliminary inquiry is made compulsory. Following the judgment of the Supreme Court, Constitution Bench judgment, Dalita Kumari versus State of UP. Now the legislature said that here it is the police officer is enjoined with a duty to hold inquiry in respect of offences which are punishable for 3 years and 7 years, and he must hold inquiry. And he must report to the victim the progress of the investigation, which was not so earlier. Isn't it? So these lacunas are sought to be withdrawn, and very importantly, the provisions of both the CRPC, IPC, Indian Penal Code, they did not have definition in a sequence of order, in a chronology, alphabetically. Now the attempt has been made in all the three legislation to give definition as far as possible of several words and meaning in an order of chronology, in a sequence of order, alphabetically, which I will take you through in the matter. Now, you all know that here the present day Indian jails are flooded with under trials, and there are several under trials who may be liable to, who will be required to punish for maybe 2 years, 3 years time. The courts are unable to take up the matter. So for minor offences, the legislature has recognized one more way of punishment, that is called community service, by adding the definition in the CRPC and also amending the provision relating to punishment in the IPC, that is the Bharatiya Satya Diyam. In the Bharatiya Nayasin, Bharatiya Nayasin, that is the Indian Penal Code. I will take you through. So before I take you through the variant salient feature, I would like to first take you through the provisions and salient features of the provisions of Bharatiya Nagarik Suraksha Sanhita, that is 2023, that is new CRPC. For the sake of brevity, we'll call it new CRPC because the name is quite sweet but lengthy. We may be able to sometimes forget it in the court of law. Yes. Now, I will take you through the provisions of the Bharatiya Nagarik Suraksha Sanhita, that is 2023. Now its aims and objects. Now this was introduced, as I told you, on 11th of August 2023 to replace the CRPC, old CPC. The old CRPC had section 484 sections, whereas the new BNSS, so we'll call it a short term, BNSS, that is Bharatiya Nagarik Suraksha Sanhita, it has 531 sections. Now this is for your reference. Yes. Now why was it enacted? This was enacted. The existing laws were from the colonial era, as they were the exact replica of the British criminal jurisprudence, and those were designed to rule and oppress the Indians and not to serve or provide justice, but merely to punish them. And many of the sections were irrelevant in the current scenario, as a society we have to come a long way and evolve a very aspect as a society. One of the major needs to constitute the act is to make the criminal system more efficient. Now the reason for enacting the old CRPC, amending the CRPC and introducing Bharatiya Nagarik Suraksha Sanhita is number one, fast and efficient justice system is essential component of good governance. However, delay in delivering justice due to complex procedure, large pendency of cases in the court. Number two, low conviction rates, insufficient use of technology in legal system, delay in investigation, then inadequate use of forensics are the biggest hurdles in the speedy delivery, which impacts the poor man adversely, as you know that. Then in order to address these issues, a citizen-centric criminal procedure is the need of the hour. The above problems, inadequacy in law, call for the comprehensive review of our criminal laws, including Code of Criminal Procedure. The present BNSS, that is Bharatiya Nagarik Suraksha Sanhita 2023, makes radical changes in the CRPC and provides for use of technology, forensic sciences in the investigation of crime, and furnishes lodging of information, service of summons, etc. through electronic communication. Yes. Yeah, in order to address these issues, citizen-centric criminal procedure is the need of the hour, as I mentioned to you. The above problems, I think we have repeated this. I will not again repeat them. Yeah. Now, another salient feature of the CRPC presently is that the specific timeline has been prescribed for time-bound investigation and pronouncement of judgment. Citizen-centric approach has been adopted for supply of copy of FIR to the victim and to inform them and to inform them about the progress of the investigation, including by digital means. The police officer has to inform you by giving in WhatsApp what step he has taken. You lodge a FIR, you know that under the old CRPC, the police officer doesn't bother to inform you. And you do not know, you are kept in dark about the entire matter. You do not know whether any action has been taken. And you may be a victim and you may not be actual informer. You know, criminal law can be set into motion by any Tom, Dick and Harry. Unlike the civil cases where doctrine of locus standi applies that the plaintiff, the aggrieved party must file the case, civil cases. Whereas a criminal case, the first information report can be lodged by your neighbor, can be lodged by your friend, can be lodged by your brother. It can be lodged by a stranger who has seen the incident. For example, of such cases are res gestae, applicable under Section 6 of the Evidence Act, where a mob making cries, makes statements that A has killed B, and you are one of the participants in the mob. You go and report to the police officer. I have seen a commotion at a particular railway station. There was a death of one person, another person. They were beating him and they were shouting. They were raising slogans. So you can be an informer. The victim has been brutalized. He doesn't come to know. He has become total. He is in no sense to understand what happened. He has been hospitalized. Then he comes to know after 7, 8, 10 days. By the time you lodge the information. But he as a victim has a right to know about the progress of the matter. Now this present CRPC, Bharatiya, Nagarik, Suraksha, Sanhita makes it compulsory for the investigation officer that within 90 days he must inform the progress of the investigation. He must send in the information through email, through WhatsApp. Now, one more interesting aspect of the case is that under the CRPC, government has a right to withdraw cases. The moment government is changing, a government files a cases against the political opponent. The new government comes after 5 years. They want to withdraw cases. That withdrawal is done under the Section 320 of the CRPC. All of you know that. And the victim doesn't know, is kept in dark. Now it is mandatory under the provisions of the new CRPC, Bharatiya, Nagarik, Suraksha, Sanhita, that notice must be given to the victim. Without his consent and permission, you cannot withdraw the case. That is a laudable object under the CRPC. Now, summary trials have been made mandatory for the petty less offences. Now, under the old CRPC, one of the trials that is called summary trials was at the discretion of the magistrate in petty offences. Now, the court says that in the new code, they are compulsory, mandatory. They should be disposed of as early as possible. In summon cases earlier in the CRPC, there is no provision for discharge of the accused. A complaint is filed by A against B. For quashment, you have to go to the High Court under 482 CRPC, or you have to go to the Sessions Court under 397 CRPC. Now, fortunately, a new provision is added in the CRPC in the BNSS that the magistrate has power to look into the grounds of the allegation made in the complaint and discharge. That's beautiful. Time will be so much saved and much more agony. Going to the High Court, spending so much money, going to the Session Court, filing a revision or filing a writ petition in the High Court is a time-consuming process. Poor people cannot afford it. So it's one of the laudable steps which has been taken. That's true. Then magisterial system has been streamlined, as you know, in the CRPC. Then I will just cover some of the more features. There is the accountability of the police. Police officers, as I told you that here, they are bound to investigate the crime as early as possible, inform the informer as well as the victim, send them email messages, send them WhatsApp messages, the progress. And they cannot delay the matter. Preliminary inquiry, if any, should be held within 14 days under the present system of the Act, which provision was not there available earlier. Now, another laudable object, salient feature of the new Act is registration of a zero FIR. The concept of zero FIR is unknown in the old CRPC, section 154. Now, the present CRPC makes a provision that FIR can be lodged in any police station, irrespective of where you are residing, where the crime took place. It is the duty of the police officer to transfer it, not yours. Not yours. So it's one of the progressive step in the direction. Then police officer must complete the investigation within 90 days. See, the police officer is made accountable. Then trial to be conducted electronically. All witness summons to be issued by electronically. And the accused persons need not be brought to the court, because for normally remand stage, as you know that here, it is mandatory that the accused must be brought to the court. There is no need to bring now. He can be electronically examined by the court, asked question by the magistrate. Number one, did the police officer treat you well? Were you assaulted? Were any injuries to your body? Were you taken to hospital? Do you have any complaint against the police officer? Do you have a lawyer? You do not have a lawyer. The court will give you one. Free legal aid society is mandatory under Article 21 of the Constitution of India. Every accused must be given a lawyer of his choice. Under Article 22 of the Constitution of India, a free legal aid society. It is a mandatory. My magistrate is bound to ask him. Then trial to be there. Then state cannot withdraw. I mentioned that. Police to inform the victim is judgment to be delivered by the criminal court within 45 days from the date of the conclusion of the trial. So even the magistrates and session judges in the criminal court cannot relax. Of course, they are working very hard. There are too many cases. They are overburdened with cases. Now, in order to make this legislation more effective, the government has to appoint more judges. The government has to provide electronic facilities. There must be facilities of email. There must be facilities of free, what you call it, you cannot have internet without Wi-Fi. There must be Wi-Fi. If you do not have Wi-Fi, the government will not be in a position to, the courts will not be in a position to dispose of the matters expeditiously. You will not be in a position to bring the accused to the court of law. There cannot be video conferencing. So these are the matters which are essentially brought down by the court. Now, now these are the essential features in the CRPC. Now, I will take you through. Give me the notebook. Yeah. Yes. Yeah. Now let us see how the government has derived the power. Now, to make these laws, you know that under the provisions of Article 246(2) of the Constitution of India, both Parliament and the state legislatures have power to make laws in respect of matters enumerated in the list, namely concurrent list. Now, the Criminal Procedure Code falls in entry number 2. The IPC falls in entry number 1 of the concurrent list. So, the CRPC, that is Bharatiya Nagarik Suraksha Sanhita 2023, has been enacted taking recourse to entry number 2 of the concurrent list by the Parliament. Of course, every state has power to make amendment. No, every state government has a right to appoint magistrates, has a right to appoint the police officer, public prosecutors to conduct the trial. Now, how the criminal system, how the criminal courts work, I will briefly take you. Now, the significant changes which are brought. Hello. The significant changes which are brought about in the CRPC, namely Bharatiya, introducing Bharatiya Nagarik Suraksha Sanhita. You may recall that in the old CRPC, 1973, there were metropolitan areas and metropolitan courts. In a city like Bombay, we have metropolitan courts. And in district area, you have judicial magistrate first class and second class. All of you know that. Those, if you go to Pune, Kalyan, if you go to Thane, you will find judicial magistrate first class, second class. In the city of Bombay, Calcutta, Madras, Ahmedabad, you will find metropolitan magistrate. So the metropolitan area, you have to understand what is the meaning of metropolitan area. A metropolitan area comes is under section 8 of the CRPC 1973. A metropolitan area means a city or town with a population exceeding 1 million is regarded as a metropolitan area. This is in the old CRPC section 8. Now the presidency towns of Bombay, now Mumbai, Calcutta, now Kolkata, and Chennai, and Madras and Chennai, and Ahmedabad were declared as the metropolitan areas pursuant to Section 8 of the CRPC. Why I'm mentioning this because the new Act Bharatiya Nagarik Sanhita has abolished the metropolitan area, metropolitan courts also. I'm coming down. Then next topic is under Section 16 of the old CRPC 1973. We are still following it. I cannot say it is old now unless the new act is brought into force in July 2024. We are still governed by the CRPC 73. So under Section 16 of the CRPC 1973, the courts of metropolitan magistrates have been defined under Section 17 of the Act and speaks of chief metropolitan magistrates and additional chief metropolitan magistrate. So in the city of Bombay, the Esplanade Court at Kalagoda, the Kalagoda, we have a chief metropolitan magistrates court, isn't it? Then we have additional chief metropolitan magistrates in several districts like Bharatiya, we have a Bandra, we have for Andheri, we have a Borivali. These are the various districts, metropolitan areas in the city of Bombay. Now the present act, then Section 8, 16, 17 dealing with metropolitan area and metropolitan magistrates have now been deleted. Under the present act, please note that the Bharatiya Nagarik Suraksha Sahitya 2023 abolishes completely Section 8, Section 16 and 17, which dealt with metropolitan area, metropolitan magistrates and additional metropolitan magistrate. There. And in its place, now वो निकाल दिए तो क्या लेके आए? And in its place, under the new act, namely under the BNSS, Bharatiya Nagarik Suraksha Sahitya 203, the new act speaks of courts of judicial magistrates. Judicial magistrates courts of judicial magistrate. Judicial magistrate in BNSS. Section 9 is brought on the statute book dealing with the courts of judicial magistrate. Now the present Bharatiya Nagarik Suraksha Sahitya that deals with now judicial magistrate first class, JMFC court. Now the courts which were earlier in Pune, Thane, Kalyan are now brought back on the statute book even for places like Bombay, Calcutta, Madras, Ahmedabad. So we have judicial magistrate first class, JMFC court, and judicial magistrate second class. In every district, which the state government establishes after the consultation with the High Court. So the appointment of this judicial magistrate first class, the judicial magistrate second class is left to the government after consultation of the respective high courts. In the state of Maharashtra, of course, the state government will consult our Bombay High Court for appointment of these officers. Now, under Section 10(1) of the Bharatiya Nagarik Suraksha Sahitya, so I'll call it in short BNSS. The High Court also appoints judicial magistrate first class, additional chief judicial magistrate who shall have all the powers of judicial magistrate under the new code. So section 10(2) याद रखिए आप. Then under section 10 subclause 3 of the BNS, that is Bharatiya Nagarik Suraksha Sahitya, the High Court was designates the judicial magistrate JMFC into any subdivision as subdivisional magistrate. So उन्हीं के अंदर एक another new hierarchy is created, a subdivisional magistrate. Then under section 23(1) of the BNSS, that is Bharatiya Nagarik Suraksha Sahitya, the judicial magistrate may pass a sentence up to imprisonment for a year, not less than 7 years. That is earlier the powers of a metropolitan magistrate. 7 years. On a few that these are the matters you can try. Then under section 23(2) bracket 2, the judicial magistrates first class JMFC court passes a sentence not exceeding 3 years or fine not exceeding 50,000. Now यहाँ पे 50,000 कर दिया गया है अभी. देखो 50,000 कर दिया गया है in place of earlier it was lesser amount. Comparative table. Remember this here. There's a table here. Yes. So under section 23, subclause 2, JMFC, judicial magistrate first class, can pass sentence not exceeding 3 years. Fine not exceeding 50,000. The earlier power was he could only impose a fine of 10,000 rupees. Now it is increased to 50,000 under the new act. Then there is a new, apart from this, the magistrate has the discretion to pass an order, punishment, which is common now known as community service. Community service is a newly prescribed punishment. Please note that. They're very interesting. Is a newly prescribed punishment which is defined under section 4F of the Bharatiya Naya Sahitya and defined in the explanation to section 23 of the BNSS. Now, if you have got a copy, please open your BNSS. What does you mean by community service? Community service shall mean the work which the court may order a convict to perform as a form of punishment that benefit the community, for which he shall not be entitled to any remuneration. So the accused must be guilty of petty offense. Chori kiya hoga 200 rupees from your purse. For the purpose of 200 rupees, you are not going to send him jail for 10 years, isn't it? 1 year, 2 years, maybe 3 months. Sometimes the court says that probation of a good conduct, he releases him in a bond. All of you know that. If he's a first time offender. Now bond ki jagah, now the jails are overcrowded. All of you know that our Indian jails are overcrowded. Jagah nahi rehne ke liye. Many people love to commit crimes to go because they get free food. Isn't it? So with a view to remove the burden of the jails, overburdening of jail, the legislature has very cleverly and smartly introduced the new definition of community service, both in the IPC, in the punishment column. See section 4F of the IPC. See, if you see, because the IPC being a substantive law, you had to see IPC निकालिए जरा, IPC section 4 है. The IPC मतलब सारी the Bharatiya Nyaya Sanhita 2023. Those who are having, please just open it up. I will read you through section 4. Section 4 निकालिए. That is definition. Punishment. Definition of punishment in the present Bharatiya Nyaya Sahitya 2023. There are punishment number 1, death penalty, 4A. Number 2, imprisonment for life, B. Number 3, imprisonment which is of his own description, namely rigorous imprisonment with hard labor or simple labor. Forfeiture of property, and finally C देखिए आप 4F, community service. But the definition clause in the Bharatiya Nyaya Sahitya, that is the present IPC, there is no definition. There is no definition of community service. Now section 2 से check करेंगे आप. Act से A, B, C, D, they have arranged in a sequence of order, alphabetically, chronologically, but some of the expression they have omitted here. Now, fortunately, this expression, community service, has been defined in section 23.2 of the CRPC, that is a Bharatiya Nagarik Suraksha Sahitya 2023. निकालिए section 23.2. I will read it for you and explain. Now, section 23 deals with the sentence which the magistrate may impose. And I just told you that here, the court of judicial magistrate may pass sentences authorized by law except sentence of death, imprisonment for life, or imprisonment for a term exceeding 7 years. So this was the old section which has been maintained even in the CRPC. Now the second one is the magistrate, the court of magistrate of the first class may pass sentence of imprisonment for a term not exceeding 3 years and a fine not exceeding 50,000 now. पहले 10,000 था fine, अभी 10,000, 50,000 कर चुके हैं. Or both or community service. See here, this is the significant change brought out both in the CPC, the CRPC and CRPC and as IPC, that is Bharatiya Nyaya Sahitya 2023 IPC and Bharatiya Nagarik Suraksha Sanhita 2023. Now the definition of the even 23.3, section 23 subclause 3 के अंदर भी the court of magistrate of second class may also sentence imprisonment for a term not exceeding 1 year, that is the earlier powers are retained, and fine not exceeding 10,000. Earlier you could only impose fine of 1,000, 5,000, अभी increase कर दिया गया 10,000 under the new act. Plus or both are community service. See this one. Now the expression community service. See, community service shall mean the work which the court may order a convict to perform as a form of punishment, which I read out to you under section 4 of the Indian Penal Code. That is the Bharatiya Nyaya Sahitya punishment. That benefits the community, for which he shall not be entitled to any remuneration. In fact, there are several orders which are being passed by Supreme Court and various High Court. When the accused is applying for a bail, one of the conditions the judges are imposing, go and plant trees, go to the old aged home and do some service. Go and do cleaning of the parking areas. Go and assist the constables Go and assist the constables who are managing the signals, traffic constables. So these are all services, community services. For petty offences, which are punishable for up to 2 years, maybe 3 months, 6 months, small offences. Normally in a trial, which is summary trial. So this is a very welcome step on the part of the Indian Parliament in introducing community service, which will definitely ease the burden of the jail authorities and convicts unnecessarily, because you come to know the Supreme Court recently passed an order. The man 498A का matter था. He was convicted and kept in jail for 30 years. The matter, he approached the Supreme Court challenging his conviction. The Supreme Court was shocked. No offences made out against him under 498A. The man was languishing for 30 years. 498A, you are not supposed to be kept more than 3 years. 30 साल से जेल में था. It's very unfortunate. Many times the jailers forget what is the punishment which is awarded to a man. Many times on account of poverty and also on account of several constraints, the convicts do not know what they are doing. They are happy being in jail. They have no other choice. Now, the legislature fortunately has taken this step in introducing the community step, which is a welcome step in the right direction. Yes, then community service, you learned it now, judicial magistrate. Then these are the basic changes. Now, since I want to go in a sequence of order, of course, if we go through the various sections and what is minor changes, major changes brought about, will take a long time. But we are covering the main salient features. Now, as a practicing lawyer, or you are a student, you are proposing to become a lawyer, wanting to become a lawyer, then you should know how the criminal law works in the court of law. You should know not only the criminal law, even the civil courts, how they work in law. And you should not exactly go by section, section 1, 2, 3, 4, 5 used in CRPC or in the Evidence Act or in the IPC or in the Code of Civil Procedure. And I will tell you the right direction as to how you pursue the matter in a criminal court. So you learned about the courts here. Now the various criminal courts are the highest court, of course, the Supreme Court of India. Normally there are no direct trials. The High Court, there are trials take place under the special legislation. The Court of Session is the court of original jurisdiction in many criminal cases under the special legislation. Under the scheme of the CRPC, the Court of the Magistrate, now not Metropolitan Magistrate, now Judicial Magistrate, as per the provisions of Bharatiya, Nagarik, Suraksha, Sanhita, he is a court of original jurisdiction. For the purpose of a civil court, the court of original jurisdiction is the trial court that you learned under the provisions of section 9 CPC, 14, 15, 16, 17, 18, they tell you about the jurisdiction part. So similarly, under the scheme of the CR, criminal justice system, the criminal law is set into motion by the presentation filing of a document called First Information Report, FIR. Unfortunately, the expression FIR is not defined in the present CRPC, Bharatiya, Nagarik, Suraksha, Sahitya, nor in the Bharatiya Nyaya, Sahitya 20. They should have done it. They have missed the opportunity, the legislatures. The common man will come to know what is, he would not know what is FIR, First Information Report. But the legislatures should have thought it fit to give a definition, some definition of it. They are calling a report under the provisions of section 154 CRPC, now under the provisions of section 173 of the BNSS Act as a information. We call 173. When you see open 173 of the Bharatiya, Nagarik, Suraksha, Sahitya. That is 173 is analogous to section 154 CRPC. Now the expression they use here, information to the police and the powers to investigate. Now what they take information. So normally in legal jargon, from the various pronouncement of the Supreme Court, we all know that even a illiterate man knows that FIR. It is very common. FIR जाके lodge करेगा. But FIR should have been defined. Unfortunately, they have not done it. We can give a recommendation. We can inform the honorable ministers, please include this definition too. That would be worthwhile. So, as I told you that a criminal law is set into motion by the presentation of a document called FIR. Like a civil court is set into motion by the presentation of a document called plaint under Order 4, Rule 1 CPC, read with Section 26 CPC. Without plaint, you cannot move the civil court. So similarly, you cannot move the criminal court without there being a FIR. If the police has not registered FIR, you have a right to file a private complaint too. Formerly under section 200, now under the sections are little changed now. You have a right to file a private complaint. Now let us first discuss the relevant material under FIR. FIR can be filed only in respect of cognizable offences. Now you know that under the scheme of the CRPC, offences are cognizable, non-cognizable. In case of cognizable offences, the police officer can investigate without the authority sanction of the magistrate. In cases of non-cognizable offences, I mean they are more serious offences, punishable for 3 years and above. In cases of non-cognizable offences, which are normally punishable below 3 years and up to 3 years, the police officer cannot investigate without the sanction and permission of the magistrate. So there are offences bailable and non-bailable. There are offences which are compoundable, non-compoundable. So when you see the first schedule of the Act, you will come to know. Now, for the purpose of commencing your first information report, lodging a FIR under section 173, what you need is offence must be cognizable. Mean a police officer has a right to arrest without the sanction of the magistrate. Now, right to arrest is now circumscribed. There are several impediments created in the way of the officer. You cannot arrest as a matter of course under section old 41. You are required to give a notice under 41B. Now the new sections in the Sahitya are 35, I think it is there. 35. Section 35 deals with the arrest of person in chapter 5 of the Bharatiya Nagarik Suraksha Sahitya. Now section 35 is analogous to section 41 earlier. उसके साथ में the notice is now required to be given, which was earlier procedure. Now here this act is very complete. Now you are required to file the, let us understand what the FIR, what the present, the earlier FIR provisions were not satisfactory, do not meet the requirement of Article 14, 21 Constitution, dignity of the victim. Victim had no rights, and there is no expeditious proceeding. The police officer can register the FIR, not register on his own whims. And when he doesn't register, we have been going to magistrate under section 156(3). And otherwise, we are also moving the courts under Article 227, 226 of the Constitution of India for seeking a writ of mandamus, seeking a direction that the police officer must register. ये सब करने की जरूरत नहीं, isn't it? Now this provision 173 makes a provision for zero FIR. Remember the first zero FIR. It starts with every information relating to the commission of offense, irrespective of the area. This was not there. This expression, irrespective of the area where the offense is committed. 154 May, a sentence was missing. They have introduced now. Very good step. It's a progressive step, a laudable steps. Now, the new section 173 of the BNSS relating to FIR permits the informer to give information relating to cognizable offense by electronic communication. You need not go to the police officer immediately. बैठे बैठे घर में आप ईमेल भेज दीजिए, send a WhatsApp to the police officer in charge. Now this electronic communication was not in existence earlier under section 154 CRPC. This is also a very laudable step on the part of the government in introducing this act, in this provision. Next is, it is now mandatory for the officer in charge of a police station to take on record the electronic communication on being signed within 3 days by the informer. So you must have come to know about the offense. You had no time to go to police station. आपने भिजवा दिया. But you are required to sign because one of the requirement is the FIR must be signed. First information. So within 3 days you must go and sign it. So the obligation is cast upon you that expeditious follow-up is necessary in the matter. You just cannot sleep. FIR file करके. So officer must within 3 days register it. So in the earlier section 154, there was no such provision of electronic communication. Okay. Then section 173(3) is a newly added section which provides for preliminary inquiry by the officer in charge of a police station to ascertain whether there exists a prima facie case for proceeding in the matter within 14 days. probably, of course, this provision of inquiry was not there under 154. Now, the legislature has borrowed this from the Supreme Court judgment, Constitution Bench judgment in Lalita Kumari versus State of UP, where the Supreme Court had laid down inquiry should be held in certain cases. Matrimonial cases, family disputes, arrest is not automatic. Isn't it? The Supreme Court laid down several guidelines, including inquiry. Because 498A cases में बहुत सारे लोग को अंडर कर देते, husband and wife on all relatives, father-in-law, mother-in-law, sister-in-law, nephew, brother and sister. Now there came the Supreme Court judgment in Agnesh Kumar's case. Guidelines were laid down by the Supreme Court in Jogendra Kumar's case. Arrest should not be done automatically. You must hold inquiry. Lalita Kumari laid down a Constitution Bench judgment of 5 judges. Inquiry is necessary. So fortunately, the Parliament has heeded the Supreme Court advice and brought this much required change in the composition of FIR by incorporating that here. Inquiry must be instituted in certain cases where offences are punishable for 3 years and 7 years. And the IO must seek the permission of the Superintendent of Police, because he is a junior officer. He may not be fully conversant with law and the procedure police manual. Yeah, her police manual of the state may this provision contains. Inquiry must be held. Almost every police manual. A senior police officer, they all know that. A young police officer who has joined the services 6 months ago, 1 year, 2 years, he would not know. He requires training. So rightly, the legislature says that here, he must consult his senior, the Deputy Superintendent of Police, who will consider the matter, the gravity of the offences, for holding preliminary inquiry, whether there exists a prima facie case, for proceeding in the matter within the period of 14 days. 14 days time लगा दिया गया है. Time limit. Don't delay now. Don't sit on the FIR. You see the plight of several criminal cases all throughout India, also in Mumbai. The police officers are overly busy. You can't blame them. So much of crime is taking place and there are no facilities. And magistrates' courts are overburdened. Each magistrate is keeping 100, 200 matters. A poor magistrate has to handle 6 to 7 police stations. He will not be able to touch any of his partnered matters. He will be busy attending to the remand matters, where there are 200, 300 accused every day. When each police station brings a police station waiting करते हैं, इसीलिए this new act says that they need not be brought to the court. Electronically examine करो उनको. Police station से ही time हो जाएगा. That's a very interesting, a remarkable amendment in the right direction. Such a waste of time. But उसके लिए state government has to provide facilities. You cannot have online facilities without email, without giving Wi-Fi facilities. In one of the cases which went to Supreme Court, where the farmers' agitation case, you must be aware of it, in Lakhampur district, the Allahabad High Court gave a bail order in favor of the culprit, the accused, in a murder case. So in that farmers' agitation, 5, 6 of them were killed. The minister or his son took his truck, गाड़ी लेके घुसा के मार दिया गुस्से में आके. At the time it was a corona time, COVID-19 was prevailing. Most of the courts were functioning online. The judgment of the Supreme Court is very clean in that point. The order of granting bail was challenged by the victim. It's a leading judgment. This is a reported judgment. Read the judgment in the name of Jagjit Singh's case, where the Supreme Court laid down the guidelines. The Allahabad High Court committed an error of law in not listening to the victim. The participation of the victim is a must. Victim ने कहा उनके counsel, while the arguments were in progress, we were disconnected. We were offline. Our video got disconnected. There was no Wi-Fi. So there's a denial of justice. The matter should have been adjourned by the court, by the High Court.
Lecture, sir.
Ji? Anybody is asking some question? The
I have shared
honorable.
the judgment on group.
हाँ ये judgment is there. Jagjit Singh's case निकाल दीजिए. Jagjit Singh versus. I'll give you the judgment detail. Jagjit Singh versus Ashish. He is Ashish, no? Ashish Mishra, a minister or a minister's son. Is a very famous judgment. All of you know that. It is also known as Lakhimpur. Can I guess? Lakhimpur it is. Lakhimpur Kheri violence case. Jagjit Singh versus Ashish Mishra. This is the judgment where the Supreme Court put its foot down. The participation of a victim must be from the beginning till the end. From the stage of the FIR till the conclusion of the trial, till the conclusion of revision, and till the conclusion of the appeal, even Supreme Court. You cannot shut the door for the victim. Probably the Parliament, in its wisdom, has taken lesson from the judgment of Jagjit Singh and has rightly amended the various provisions of CRPC and the IPC, that is Bharatiya Nyaya Sahitya and Bharatiya Nagarik Suraksha Sahitya. Victims' rights have been recognized. Please read all of you the judgment. This is a landmark judgment which I had referred to earlier judgment, and also the various provisions of the international treaties. So on account of this judgment is reported in, I think, 2022. Just check all of you. The date I can give you when the judgment was passed. I think that it was a judgment rendered on 18th of April 2002. Chief Justice Ramanna, Justice Suryakant, Justice Hema Kohli. These are the authors. Author was Justice Ramanna. One of the beautiful judgment. Please go through, all of you. Must read this if you want to know. Yes. Yes. Then 14 days ago. Then preliminary inquiry is made mandatory in cases of cognizable offences punishable from 3 years to 7 years. That means 3 years, but less than 7 years. In serious cases like murder, rape, there is no inquiry required. Police officer has a right to arrest immediately. Otherwise, if you hold inquiry, evidence will disappear. Isn't it? Our accused persons are smart people. They will caused the disappearance of the evidence. That is why the police officer, the check and balance is there here. In serious offences, yes, the police officer rightly has the right to arrest immediately. Then the officer in charge is obliged to take prior permission of the superior officer below the rank of deputy that I discussed with you. Now, this provision relating to inquiry, preliminary inquiry, was not there in section 154 CRPC and has been introduced for the first time in the BNS in 2023. Yeah. Yeah. Next. Under section 173(2) of the BNSS, Bharatiya, Nagarik, Suraksha, Sanhita 2023, for the first time, law provides for copy of the FIR should also be given to the victim, who may or may not be the informer. So informer is different. A victim is different. As you know that in several rape cases, woman out of social stigma, she doesn't approach. She will inform her family members, mother, brother, sister, I was ravished. So the complainant will be one of the member of the family. And the girl is a victim. So as I informed you that, told you, criminal law can be set into motion by anybody, except certain offences like defamation or personal cause of action. But all other offences, anybody can fight. The doctrine of locus standi is open very wide here. Yes, that is a very interesting step here. The victim must be given. Fortunately, this is following the judgment of the Supreme Court in Jagjit Singh's case. Then the other requirement of section 154 relating to information given by the women in respect of offences under section 64, punishment for rape, 65, these all they copied from the earlier FIR. I won't be repeating it. 376 for the earlier section. Now it is 64, 65, 66, where rape cases, sexual intercourse, and husband 68, 69, 70, 71, 74, 75, 76, 77, that is, and 124, voluntarily causing grievous hurt by acid. These are all offences. The law mandates here should be recorded by a women police officer or a woman officer. IO may not be a women officer, some other women officer in the police station. You cannot have a male officer to examine because the woman may not be comfortable giving a statement to a male officer. And the law says that information relating to rape and outraging the modesty, when given by women to another women officer, they must be videographed. This was also the requirement under the proviso 2 to section 154. So they have not changed it. The section was amended in the wake of Nirbhai's rape case. It was done. Then under section 173(5), 173(3), 175(3), the magistrate can only investigate after making inquiries, is a newly added section. Investigation order. Now, in the earlier section 156(3), normally the magistrate, when you make an application under 190, my lord may kindly, this is a serious matter, the police officer may kindly investigate. They pass the order under 156(3) mechanically. Now the law says that this power should not be exercised as a matter of course. It must be exercised with great circumspection and caution only after holding inquiry. The magistrate is enjoined with the duty to first hold inquiry by himself or through other magistrate who are subordinate to him. After inquiry करने के बाद ही investigation, not that a delay will happen here. Of course, substantive justice should prevail, but once you hold inquiry, then investigation, this is bound to cause some delays. But there may be some reason behind it. That means the magistrate cannot automatically pass order of investigation just because you have come before the court. This is a departure from the earlier section 156(3), where there is no provision for inquiry before passing investigation order. So 175(3) is new, please note it down. Then subsection 4 of section 175 is also a new provision. It provides that magistrate empowered under section 201 of the BNSS, 201 of the new act is equal to section 190 of the old act, where magistrate can take cognizance. May, on receiving complaint against a public servant arising in the course of discharge of his official duties, he can take cognizance. He cannot take directly, subject to number 1, receiving a report containing the facts and circumstances of the incident from the officer superior. This is a very unfortunate provision, I would say that. You are not totally trusting your magistrate. You are superimposing the senior police commissioner to record a finding, to take objection, to take no objection, and hear the public servant first. Then after consideration of the assessment by the police servant, public servant, as to the situation leading to the incident, as an issue. That means the magistrate cannot suo moto, cannot automatically pass an order of investigation against a public servant. He can only do so, number 1, the first requirement is the public servant must appear before the superintendent of police. He must be given the opportunity to explain whether the incident is correct or not. Which public officer, politician or a public servant will admit कि मैंने चोरी किया है? Huh? I have taken graft, I have done an act. Nobody will accept it. So this is giving more power to the police. The police officer is put in a higher pedestal than the magistrate. This is a very unhappily drafted provision. I am not happy with it. See, when a magistrate wants to pass an order of investigation, it is subject to the directions of the police officer, means the superintendent of police. An opportunity being given to public officer to hear it. But whereas a police officer investigating the crime under the provisions of section 17 pursuant to 175, and 175, that is power of the officer to investigate offences, he can investigate directly against a public servant without unbridled powers. Whereas the magistrate cannot do that. Public servant is insulated from the onslaught of the magisterial orders. Probably this is going to be challenged probably in the Supreme Court, and just let us see the Supreme Court what does it say. There is a you're not trusting your magistrate. That is very unfortunate. Why are you putting the police officer on a higher pedestal than the judicial magistrate? So this is definitely a troublesome provision. According to me, this needs rectification. This should be handled here. Yes. The provisions, procedure for investigation under 157, there was no provision for audio video recording. In the old CRPC, there was no provision. All of you know that 157, the old section. That is a provision for investigation. Now, under the present new section, Acha, does anyone have any question or queries? Anybody has any queries? कुछ सवाल पूछना है मेरे को? After this topic,
Sir,
है ना?
Sir, one quick doubt.
Yes.
So when the police is when the accused is not the accused, but accused is brought before the police, like there is a provision in the old act, he has to be brought within 24 hours before the magistrate. So
Yeah.
that will be also be conducted electronically, or that will still remain to be physically produced before the magistrate.
Everything is electronically. All these appearances are mostly the act is suggesting electronically.
Okay.
I'll come to that. Summons to be issued electronically. Appearance भी online सब कुछ कर रहे हैं. As far as possible. अगर नहीं होगा तो क्या? अगर आपके पास online नहीं है, Wi-Fi नहीं है, then you have to be brought to the court. The same time in the judgment of the Allahabad High Court, वहाँ पे Wi-Fi नहीं था. Is Allahabad is a big place, and the matter was argued in the High Court. The victim said, हमारा Wi-Fi छूट चला गया. I had no occasion to make my submission. The Supreme Court cancelled the bail. Read that judgment properly. And the matter was remanded back to the High Court of Allahabad High Court, to hear the parties, including the victim. I am coming to that when I am dealing with remand under section 167(2) and the present sections. Okay, I will come. Now, there was no provision for audio, video, electronic data under the old section 157. Now the second proviso to section 176. 176 का second proviso check करें आप of the BNSS, Bharatiya, Nagarik, Suraksha, Sanhita 2023. It permits the recording of rape victim statement through video, audio, electronic means, preferably cell phone का use किया है. And section 157 CRPC contain no provision. So this is in cases of the victim being a rape victim. Then another important, under forensic facilities, section 176(3) check karo of the new act. 176(3) of the BNSS, Bharatiya, Nagarik, Suraksha, Sanhita 2023 is a new provision. It provides that on the receipt of every information relating to the commission of an offence which is made punishable for 7 years or more, means serious offences, the officer in charge of a police station shall, from the date as may be notified within the period of 5 years by the state government, 5 साल दिया गया, in this regard, cause the forensic expert to visit the crime scene to collect the forensic evidence in the offense and also cause videography of the process on mobile phone on any other electronic. So scene of offense पे पहुंचेंगे police officers. By the time they reach, the evidence is wiped out. Immediately you are directed to take the forensic experts to record the video recording of the scene of the offense. The articles which are sought to be collected, the Panchanama report which you are making, the fingerprints of the accused person or you are taking, ये सब चीजें, videography, scientific examination. It's like they are court commissioners. Like under the provisions of CPC, Order 26, Rule 9 say that appointment of a court commissioner for elucidating the subject matter. Like Order 39, Rule 7, the court can appoint a court commissioner even for collecting evidence in respect of the suit premises or the premises situated outside. CPC के अंदर wide power है. Similarly, now the first time, the very belatedly, better late than never, the legislature thought of, otherwise see, many of the accused persons were getting acquitted. Investigation, हर judgment में judges कहते हैं कि investigation was shoddy. And we had no other choice but to acquit the accused. For lack of evidence. ये evidence को tight करने के लिए the government, the parliament has passed the order. Forensic expert must visit. Now, forensic experts' evidence is now a primary evidence under the new Evidence Act. Formerly used to fall under Section 65B, following the Supreme Court judgment in Tabasco Burners case and the famous judgment of the 3-bench judgment of the Supreme Court. What is the party's name? Anyone know? Justice Dariman's judgment. Under Section 65B, you must obtain the certificate.
The Arjun Panditrao Kotkar versus
Arjun Panditrao Kotkar's case. That has affirmed the earlier judgment of Tabasco Burners case. Now, the present act seeks to cure the irregularities and say that the evidence which is sought to be collected by the experts, forensic experts, and the recording which take place with your phone is all primary evidence now. It is brought within the meaning of section 65A now. It's a direct evidence. Samjana? That is how it is a laudable, but now 5 years time is given because we are not still scientifically advanced. Maybe cities ki halat theek hai, or rural areas, they needs improvement. That can be done. Now, this has to be notified within a period of 5 years time. Abhi time hai iske liye. Let it be notified. The act is 1st of July 2024 is the date set down for the act to come into force. Let us see what will happen. 20?
50 minutes.
Yeah. Now, so ये हो गया investigation part. So, CRPC के अंदर you learned that the stage is first information report and investigation. वो दोनों होने के बाद the third step is arrest. Arrest provisions in the old CRPC were section 41, 41A. All of you know that now. 41, the police officer has a right to arrest without warrant. 41A, he is required to give notices in offences which are punishable up to 7 years. Following the judgment of the Supreme Court in Arnesh Kumar's case. Now, the new section in the BNSS, Bharatiya Nagarik Sanhita, is section 35 to 62. These are the provisions relating to arrest. 35 to 62. Now, under section 35 subclause 7, 37 is newly added section. Now, this provides that no arrest shall be made without the permission of an officer not below the rank of deputy superintendent in cases where the offence is punishable for less than 3 years and the person is infirm and above 60 years. A safeguard. The offences are not very serious. Offences up to 7 years are not considered as very serious. Moderately serious, not very serious. So a person who is very sick person, you can't arrest him. And a senior citizen cannot arrest him. Then another amendment which is introduced in section 40, which was originally section 43, arrest by private persons. You know, private person also has a right to arrest. Now the time limit, the time limit for handing over the arrestee to the police officer is fixed. 6 hours. Formally under section 43, there was no time limit fixed. Because here life and liberty of a person is very important. You cannot detain him. You cannot arrest him and lock him at your house. Within 6 hours from the time of the arrest, you must reach him to the police station. You must have got him arrested in Pune, Thane, Lonavala. Take him to the nearest police station or the place where the crime is committed. There is no need to take him to the place where nearest police station. But in many places, rural area, there are no police station. People are required to walk. People do not have transportation. So the legislature thought it fit to give 6 hours time. But section 40, however, does not say what if the private person does not hand over within 6 hours. But there is no penalty or punishment is provided. So silent age, that has to be rectified, that has to be cured. Then 43(2) of the CRPC provided that if there is a reason to believe that such person comes under the provision relating to arrest, a police officer shall re-arrest him. The police taking custody of the person subject to private arrest was termed as re-arrest. Now 40 subclause 2 of the BNSS has substituted this word shall re-arrest him with the word shall take him into custody. The changes. In other words, section 40 provides police taking custody, privately arrested person is only taking him into custody. So these are minor changes. Then how about handcuffing? As per Supreme Court several judgments, arrested person cannot be handcuffed. Those guidelines were laid down by the Supreme Court in the case of the Nadiad magistrate's case, where the magistrate was paraded by the police officer, commissioner in Nadiad, making him consume liquor, parading him handcuffed. That 96 ki baat hai, just the judgment is very well known, it is on the net. Nadiad magistrate's case. So the Supreme Court took a very serious view of the matter. Handcuffs should not be allowed in a routine manner. Now the present act tells you in what cases handcuff can be used. 43(3) of the BNSS, that is Bharatiya Nagarik Shuddha Sahitya 203 tells you handcuffing can be effected against habitual offender, repeated offenders who have escaped from the custody, who have committed offences of organized crime. Organized crime is a new topic which has been added. We will take in the next lecture in the IPC, that is a Bharatiya Nyaya Sahitya. Then offences of terrorist act, drug-related crime, offences of illegal possession of arms and ammunition, murder, rape, acid attacks, counterfeit coins. So these are all serious offences which are punishable with life imprisonment or maybe murder. So unke liye this act is justifying handcuffing, and to what extent the Supreme Court will agree or disagree has to be seen. Then 105 ke andar recording of the search and seizure through audio, video, electronic means. So there was no corresponding provision in the old act. 105 provides for the process of conducting search and seizure. This I should have covered in investigation, sorry. Is made compulsory. So this is now all of you know that an arrested person should be brought in the nearest police station within 24 hours. That was the earlier section 57 of the CRPC. Now the mandate is contained under section 58 of the BNNS. Now there's a slight change in section 58 of the BNSS, which says that it modifies the provision that police detention shall not exceed 24 hours, exclusive of the time necessary for journey from the place of arrest to magistrate, whether having jurisdiction or not. So whether having jurisdiction or not is newly added. This also satisfies the mandate under Article 22 of the Constitution of India, earlier Section 57. Isn't it? Now, arrest होने के बाद 24 hours, because the CRPC criminal law expects that the investigation agencies to complete the investigation in 24 hours, which is not possible. So when they are not completing investigation, which they cannot technically, so the accused must be brought before the magistrate, the judicial magistrate, within 24 hours. That was the earlier section 167, remand provision 167, 1 and 2. Now the present section is section 187 of the BNSS. We will discuss this term next lecture. The remand के लिए remand, bail, anticipatory bail. So 167 to CRPC is now equivalent to 187 of the BNSS. 187. Procedure when investigation cannot be completed in 24 hours. The sections have been little upside down. So there will be a problem for the judges and advocates as to why these sections have been uprooted. Because they had no other choice. I feel they have deleted the old sections. Whatever may be, but we'll get used to it. We'll learn it.
Mr. Sandeep has a query. Mr. Sandeep has a query.
Sanjay?
Sandeep.
Sandeep. What is the query, Mr. Sandeep?
Sir, good evening. Can you hear me?
Yes, yes.
Sir, kindly share the screen from which you are reading the sections. That will be helpful because, most of the people are on the move and
Some of the notes
so
I have
we
prepared. I think
request.
you can refer the new book, na, Bharatiya Sahitya Adhiniyam. The book only I am referring. The notes are there, na?
These are your notes.
Huh?
These are yours.
These are my notes.
We can refer these as.
You want to share them? See, some of the notes I have prepared for myself, but they are there in the Bharatiya Nyaya Sahitya 2023. So please open your Bear and also they are there in the cell phone.
Yes, sir, but the screen you are sharing
I am
is
not good in sharing. I am not
whatever
good in
is
my computer.
visible.
I am also very. I mean,
The screen is
I'm not
frozen.
computer savvy. To must say that I'm not a computer savvy. I prefer to use my books or my notes, And my
No
notes which
complaints,
I
sir.
prepared, you will not be able to read. They are not legible. My handwriting is so fantastically bad.
No complaints, sir. No complaints. Thank you so much.
Okay.
But the screen which has been shared is frozen. So, we are unable to, grasp. Whenever you're reading, it will be better if you, we also read the section simultaneously. That was only request.
Mr. Sandeep,
बोलिए.
the sections that
Yes,
sir
yes,
are
please.
referring, the sections that sir are referring is his notes. You can rather refer these sections from the BEAR Act. The new BEAR Acts which are of Bharatiya Nagarik, Suraksha, Sanhita and all. But there are 3 of them. You can correlate from there as these are his notes and the PPT that was shared prior is being screen shared with everyone.
Yes, ma'am.
Yeah, I
Got
forgot
it.
to inform you all. Please lectures के अंदर बेर एक्ट रखिए सबके. हाँ? एक बेर एक्ट या
Yes,
criminal
sir.
major act
Thank
रखिए.
you.
That is very important. Of course, in the mobile phone, because to be frank with you, I am not a computer savvy lawyer. I am now 65, 67. So you understand that. So you people are young people, may be familiar with computers. So
Sir, share
fortunately,
the Bear
I wanted to young people who know the computer. Okay.
So there's one Deepak Pandey.
what is the question of Mr. Deepak Pandey?
Namaste, sir.
मुंबई के अब मुंबई के बाहर के हैं?
No, sir. Actually, I properly belong from Varanasi.
वाराणसी से हैं आप. Very good.
Yes.
जी
So,
बताइए.
Namaste, sir. Actually, I had a query, sir. The term mental unsoundness, which were defined, which were actually used in the Indian Penal Code, Criminal Procedure Code, and
mental
etc.
unsoundness lie in place of idiot निकाल दिया अभी. Oh, जब वो बताएंगे.
Yes.
When we do the word expression
Okay,
क्या
sir.
नाम है? Idiot और mental वो निकाल दिया.
Yes, sir. It has been replaced with the term mental illness. Now, mental illness, it is a medical condition, while
Yeah,
the
medical.
mental unsoundness, it is a legal finding. So, please, can you shed the light on what is the critical and precise distinction between these two terms which have been replaced
When I
in the upcoming, this
discuss
Bharatiya
with you the Indian Penal Code, Bharatiya न्याय साहित्य जब करेंगे हो. हाँ?
Okay, sir. Thank you, sir. Thank you. Thank you.
Indian Mental Health Act भी देखो उसके अंदर.
Yes, sir. It was actually only defined in the, the contract act.
It was under Indian Lunacy Act, which was abolished. Then Indian Mental Health Act 2014 के अंदर वो भी abolish किया. Then
Yes, sir. The Mental Health Care Act of 2017.
Mental Health Care Act है, isn't it?
Yes, 2017. Yes, sir.
Care Act, वो Care Act. These three acts you refer to, मैं सब आंसर मिल जाएगा.
Okay, sir.
और कुछ है आज के लिए वाइंड अप करेंगे.
Sir, did you vote?
जी? Yes. I have gone. You want to see my vote? This is my vote. We all must exercise our civics rights. Yes, Mr. Gaurav.